Good day, and welcome to this course on the preparation of NDNT citations, long-form warrants, complaints, and court filing procedures. My name is Assistant Chief Dino McNeil, and I will be your course instructor. The reason for this course is that there's been many changes in the laws pertaining to the preparation of these types of documents over the past few years, and since our department really does not engage in utilizing those documents that frequently, it's good to do a refresher training and to make sure that everyone is on the same page regarding these types of documents and how we prepare them and how we file them. With this in mind, let's review the objectives for this course. Our first objective is to help you learn the procedures for preparing NDNT citations. Second, we want to help you learn how to prepare and use personal identifier forms. Third, we want to help you learn the procedures for preparing long-form warrants and complaints. Fourth, we want you to learn the procedures for preparing a probable cause affidavit. And finally, we want to help you learn the procedures for filing these various types of documents with the court and to be able to properly make copies for distribution and know where the different copies need to go. Let us begin with the examination of how to properly prepare and file our Notre Dame non-traffic citations, the NDNT citation. Here is a sample of an NDNT citation. This form is pretty much typical of the types of summons forms that you would find used in most of the courts within the state of Ohio. This form meets the standards required by the Ohio Supreme Court and the Ohio Revised and Administrative Codes. Here is a sample of an NDNT citation. This form is pretty much typical of the types of summons forms that you would find used in most of the courts within the state of Ohio. This form meets the standards required by the Ohio Supreme Court and the Ohio Revised and Administrative Codes. So to help offer you some guidance in how to properly prepare the NDNT citations, we've created a fictitious charge against a former student, Joe J. Smith, who has committed the offense of criminal trespass here at Notre Dame. So if you look in the top part of the form, the first block that we would check would be in the South Euclid Municipal Court. Again, this form is only used for South Euclid Municipal Court for our department. Then on the next line, you notice that it states on Monday, the 19th day of October 2015 at 10 o'clock a.m. Now you want to make sure and list it in this form, the day a week, the date, the month, the year, and the time of the offense. And we would list the location, 4545 College Road, Harks Hall Room 120, South Euclid, Ohio, and put the zip 44121. When putting the location, we want to try to be as specific as possible. If it occurs in a residence hall or a building, we want to note that. We want to note an office or room number if possible. But it may be a situation where it occurs out on the grounds or in the parking lots, and in those type of cases, just simply 4545 College Road, South Euclid, Ohio is fine. On the next line, we'll list the name of the person being charged. Last name, first name, middle initial. Then we're going to list their home address. On the street line, we'll list the street address, number and street name. City and state, Cleveland, Ohio, zip code. And then you want to try to get the telephone number if you can, preferably their cell phone number. If they are a student or a former student, if you can't get a cell phone number, you should be able to get into the CAR system and at least get a telephone number for their home of record. On the next line, we want to list their operator's number and state ID, or state ID rather. And in most cases it's going to be Ohio, but if it's an out-of-state one, or even if it's in Ohio, list the state it's from. It makes it easier, and if we have to run this in the future for some reason. The next line is for Social Security number. Back in the day, we used to list the full Social Security number. Well, with the changes in rules of the Ohio Supreme Court, we do not do this anymore. So in this case, we are always going to use this particular format, XXX-XX- the last four of the Social Security number. That will be the standard format used. On the next line, we'll list their age, we'll list their date of birth, we'll list their gender, their height in inches, and then their weight. In the next section, we're going to talk about the violation and list the violation information. Now, in the section marked violation name and heading, you want to identify the name of the charge that you are writing the individual for, in this case criminal trespass. You also want to put the offense classification, and this is very important because different subsections of a particular statute may affect what the offense classification is. Further, if it's an attempt versus a completed offense, that may also affect the offense as well, or the offense classification as well. So in this case, criminal trespass, misdemeanor of the 4th degree. Now on the next line, where you see where the Ohio Revised Code is checked, in this particular case we're citing the individual under the ORC 2911.21. However, if you wanted to cite them under municipal ordinance, you would go to the block marked chapter, check it, and then write the South Euclid Municipal Code number for that particular offense. If you need to find out where to get South Euclid Municipal Code from, that can be done at the City of South Euclid website. The link to the law department, it lists all of the municipal ordinances for the City of South Euclid. Now in the next section, we're going to list the narrative of the violation, and there's always some components that we have to do with this. You have to reference whatever appropriate subsection, and there is always at the end a to wit section which actually identifies very briefly the facts of the incident. Now, you're actually in a sense going to be listing all of the information contained in the statute pertaining to the offense, but realistically not everything in the statute may apply to what you're trying to do, because what you really want to have is the essential elements of the offense that you're charging with. So if you look in this case, we're charging under the A2 section. So if you go to the A section, it says no person without privilege to do so shall do any of the following. Then you'll notice ... And the reason for the ... is that's sort of a place filler, if you will, for the portions of the section that do not apply to what we're charging the individual for. In this case, the subsection A1, we're not charging the individual with that, so it doesn't apply, but we have to account for it. So the ... serves as the filler to account for that section of the law. Now in the A2 section, which is the citation, or the section which we're citing under, it's knowingly enter or remain upon the land of another, or premises of another, and then you do list the rest of the offense, and then you notice there is another ... before the words to wit, and that takes into account all of the remaining section of that particular statute. Again, then we list the to wit, which is a very, very brief summary of the elements of the affair, the facts of the offense, which align with the elements of the statute being violated. In this case, did enter into Harks Hall in violation of a no trespass letter that was served on Smith on 10/17/2015. On the bottom section of the citation, you as the charging officer will sign it. You'll check the block for South Euclid Municipal Court, which shows that the individual must appear there, and then you'll also get a court date and a court time from the South Euclid Police Dispatch Center. You could call over there, 216-381-1234, ask them what the next court date being assigned is. They'll give you that information, and that will go in this particular block. Now, after we've completed the summons, we're going to take the tan or manila colored copy of the citation, the one that's marked summons, and give that to the offender. I would also have you note that the citation blanks will not be clerked or notarized by a deputy clerk of courts or notary public prior to being served. It'll just simply be signed by the issuing officer, and the person being charged will receive their copy. Now, for the benefit of the offender, there are a couple additional things which you want to do. Explain the court date, time, and location to the defendant. It's very important that they know where they need to go and when they need to be there to go for their initial appearance. You need to also let them know that if for some reason they're not going to be able to appear, they can't appear at that initial appearance at the date and time assigned, the responsibility rests with them to contact the court and request a change of court date. You can also explain to them, and should explain to them, that if they do not contact the court and they do not appear when they're scheduled, that a warrant will be issued for their arrest and they could be picked up and incarcerated. Now, there are a few additional things which you need to do as a part of the filing process. The first thing that you're going to want to do is complete a personal identifier form. Now, these forms are used in all cases where charges are issued, be they traffic, be they criminal, be they misdemeanor, be they felony. Anything that goes into the filed with the South Euclid Municipal Court, this form has to be used, and we'll discuss how to complete that a little bit later. Now, you also want to make sure that all of the reports are completed, that copies of any statements, attachments, Miranda forms, OLEG leads, CCH printouts, everything is included with the case file, and make sure and put the personal identifier form and the remaining copies of the NDNT citation in the case file. And then turn that in, put it in the reports completed box, and the records officer will then file your charges on the NDNT citations with the court on the next business day. Now, one thing which I do want to note is that when you run them through OLEG or leads or whatnot, don't just limit your search to a driving record. Run a CCH, run them through NCIC, get a criminal history if there is one, because that information may also be relevant to the court regarding not only bond considerations if that's the case, but also for sentencing consideration if the person is subsequently found guilty of the charge. As I said, we were going to talk about the personal identifier form, and here is a copy of the personal identifier form blank. It's a really simple form to complete, and we're going to go over it quickly and show you what information needs to be in there. To begin, you want to check the block marked Notre Dame College. Then you want to list the name of the defendant on the name line, Joe J. Smith in this case. You want to put the date of birth. And here is where you're going to put the full Social Security number, which the court needs, but this particular document is not public record and the court will not release it. Now, as I said, you'll use this form either for the case of issuing a traffic citation, issuing an NT citation, or if there's a criminal charge that's where the individual is incarcerated and the long form warrant and complaint is completed. If it's a traffic citation, list the traffic ticket number in the appropriate block. If it's an NT citation, as we did here, list the NT citation number on that NT ticket number line. And if it's a criminal charge using a long form warrant and complaint, list whatever the criminal charge is, criminal trespass, assault, whatever the case may be. Then going down, you'll list your name, Assistant Chief, in my case here, Assistant Chief D.L. McNeil, and then your badge number. In this next section, we're going to learn how to properly utilize long-form complaints and long-form arrest warrants in the cases where a defendant is being charged and incarcerated at the South Euclid City Jail. Now, we're going to utilize the long-form complaint form and long-form arrest warrant form in cases where we're charging either for a misdemeanor offense or a felony charge where individuals are going to be the guest of the South Euclid Police Department and housed at the South Euclid City Jail. For your convenience, we have a number of pre-made forms that are in PDF form that are pre-made to various sections of the Ohio Revised Code, and they will be found on the department shared drive within the Police Department Files folder in a folder called Complaint and Summons Forms. And in cases where we do not have a pre-made form available, there is a Microsoft Word document forms variations in that folder that can be used for the preparation of charges that we don't otherwise have pre-prepared blanks for. We're also going to learn how to use a little bit later, and we'll talk about it more, probable cause affidavit form, and that is used in conjunction with the complaint and warrant forms. Here's a sample of a long form complaint form that would be filed under Criminal Rule 4 of the Ohio Rules of Criminal Procedure. This is one that is a pre-prepared form for criminal trespass, so the essential elements of the offense are already listed. It's going to save you a lot of time and effort, and pretty much it's just simply filling in a few blanks and checking a box. So to begin, at the top part of the form, we're going to begin by putting in the defendant's name on the defendant's name line. Pretty simple stuff. The street name, the street address, and you'll list the city, state, and zip of the defendant's home address. In this case, Joe J. Smith, 7545 Euclid Avenue, Cleveland, Ohio, 44111. Now in this middle section of the complaint form, this is where we're going to identify the essential elements of the offense that our defendant committed and list when it happened, where it happened. So here you'll see on the first line we'll list the name of the defendant, Joe J. Smith, and then it says in the city of South Euclid, County of Cuyahoga, State of Ohio, on or about, and here we would list the date of the offense. Then each of the following subsections of the statute, there's a checkbox. So since we're charging under the A2, we would just simply click the checkbox for the A2 section. The check mark will appear, and that will suffice for that. Now in the bottom part of the form, you'll notice that this section does have to be notarized either before a deputy clerk of courts, which can be done either at municipal court or the South Euclid Police Department Dispatch Center, or a notary public can do it if we need to as well. So you would not sign this form though until you have it before that respective person who is swearing you to the document and doing the clerking on it. And this would also be done before the defendant is served with his or her copies of the complaint as well. So that's one thing you keep in mind, that this section does have to be clerked. One thing that you should note about getting these documents clerked, if the documents need to be clerked during the business hours of the South Euclid Municipal Court, that should be done at the clerk of court's office at the court. If it's after hours, the complaint can be sworn to in front of a deputy clerk of courts, who would also be the communications officer at the South Euclid Police Department, or it could also be sworn to before a notary public. Next, we're going to talk about the long form arrest warrant, and this form is going to be used in cases of either an arrest with a warrant or a warrantless arrest, wherein a warrant is going to be obtained as soon as possible after the arrest, and it's used in misdemeanor and felony cases where an individual is being arrested and incarcerated. We would not use this for a misdemeanor case where we're simply issuing a summons. That we would issue the NDNT citation. Although technically we legally can, it's just really not practical to do so. We want to make sure that when we complete the arrest warrant, that a copy of the complaint is attached to the warrant, because particularly when the individual who is being charged is arrested and served, they will need to be served with both the warrant and the complaint. I would also have you note that an arrest warrant and a complaint is prepared for each individual charge. So if you're charging a person, say, with assault and criminal trespass and disorderly conduct, there would be separate arrest warrants and complaints prepared for each individual offense. Now, another thing that's associated with arrest warrants is a return, and this has to be completed when the individual's been arrested and when the warrant's being returned to the court because the arrest hasn't been made, we're returning it, or if the court is recalling the warrant for some type of reason. We would complete that section and return the warrant to the court. On a procedural note, while the complaint may be sworn to in front of a deputy clerk of courts or a notary public, only a judge or a court magistrate can review and sign an arrest warrant in accordance with the rules established by the Ohio Supreme Court. And there is a case which deals with that particular subject, which we'll talk about a little later. Now, during court hours, the warrant, along with the sworn complaint, the probable cause affidavit, again, which we'll talk about, that can be taken to the South Euclid Municipal Court. The deputy clerk of courts will take care of swearing you to the complaint and to the probable cause affidavit. Then the judge will review the documents provided. They'll review the probable cause affidavit, and they'll make a determination on whether probable cause exists to actually issue the arrest warrant. If they determine that probable cause does exist, then they will sign the judicial information section of the probable cause affidavit, which again we'll talk about a little later, and they will also sign the arrest warrant. Now, if this is after hours, the complaint and the probable cause affidavit will be sworn to, and then we would email those documents along with the completed but unsigned warrant to the on-call judge or magistrate. And again, I'll talk about the procedures a little bit later in the presentation. Now, if we are going to contact the judge or magistrate after hours and email these documents for completion, for review and completion, after the court is closed, then we need to do this before 10 p.m. We would email the appropriate documents and contact them at their home and or cell phone, let them know that these documents are in their email, and they will review them, take care of things as appropriate, email the stuff back to us. If it's after 10 p.m. and we can't get the documents completed or the offense takes place after 10 p.m., this review is going to have to wait until the next business morning that the court is open. Now, one thing that I would note is if you are the arresting officer, you're the charging officer, you are going to have to be the one who takes care of making sure that this documentation is completed. You can't turn around and leave that for day shift to do or whatever the case may be. That's got to be done by you. So be able to plan accordingly, plan your schedule accordingly, and so you can get this done. Now, there is a copy of the call schedule for the judge and magistrate when they're on call, their telephone numbers and email addresses in the warrant and complaint folder that I talked about earlier. And a supervisor needs to be contacted before this process begins, so we can just make sure to help kind of walk you through it and make sure that everything is handled properly, because we don't want any missteps to turn around and possibly jeopardize your case. So go ahead and contact the supervisor. Now, if the person, say, is arrested on a Friday, you can turn around then the next morning, come up to the station, and during the daytime hours we can turn around and do on Saturday, or if it happens Saturday night, on Sunday morning, send the stuff to the judge or magistrate as well, and they can review it and sign off on anything accordingly. But if it happens, say like on a Thursday night at 11 p.m., the person, you're not going to be able to get the arrest warrant until Friday morning when the court opens. So keep that in mind, and the person, we should be able to keep them incarcerated at the jail until such a time as we can obtain the warrant. So here's a copy of a blank arrest and warrant on a complaint, again in accordance with Criminal Rule 4. This is really a simple document, not difficult at all for the parts that you need to fill out. And we'll go over that here with the next slide. To begin, same as with the complaint, you have to list the defendant's name and the defendant's address. And there are fill-in-the-blank blocks in the warrant for you to be able to do that. In the middle part of the warrant form, you'll need to list the defendant's name where it says you're ordered to arrest, in this case Joe J. Smith, and bring him or her to this court without unnecessary delay. And it says that you may or may not issue a summons in lieu of arrest under Rule 4A2 or issue a summons after arrest under Rule 4F because, and here you need to state some type of a reason. In this case, Smith, maybe he's an out-of-state student, may flee out of state if not detained, or may fail to appear in court. Whatever the particular reason that the person should not be issued a summons, you need to list that here. You can also circle where it says him or her, circle the correct one, or the may or may not issue summons, circle that as well, just so it provides clarification to the court on what we're trying to do. Now, you've completed your portion of this arrest warrant form. The rest of it has to be completed by the judge or the court magistrate. So in the bottom section of the form, this is where the judge or magistrate does their thing. Now, if they have any special instructions to the executing officer, they will jot those on the lines above where the court's or where the judge's signature is. Now, I spoke earlier about the return on an arrest warrant, and this is on the back of the arrest warrant form or could be attached to it as well. And this is when the warrant is executed or returned, whatever the case may be. Here you would fill this section out as appropriate. This is an example of what it looks like, and in the next slide we'll show you really what you're going to be doing most of the time, and that would be filling out the section at the top where it says return of executed warrant. Now, here's an example of the return of executed warrant section being completed on the return. And you'll see that it'll be number 1, execution by arrest. And again, this is the most common way you're going to do it. So, I received this warrant on whatever day you received it, and then on whatever day that the individual was arrested, I arrested, list the name of the defendant, gave him or her a copy of the warrant with the complaint attached, and brought him or her to the South Euclid Police Department, and then you would sign it. And again, this is completed upon the execution of the arrest warrant when the person is arrested, whatever that may be, or when, if we've already arrested them, when we have obtained then the arrest warrant and we've served it on the defendant post-arrest. We would take care of doing this. Now, the next thing I want to talk about is distribution of the arrest warrant and where things need to go, where they need to be filed, so on and so forth. Now, the original arrest warrant, complaint, and completed return need to be returned to the South Euclid Municipal Court along with the completed probable cause statement, the report package along with your statements, various documents, Miranda, so on and so forth, video. We need to get the CD or DVD for the video if we do have video in a case, along with the lead statement, if we get something from Oleg, and the CCH, especially in cases like this where a person's prior criminal history may affect whatever their bond amount is, or terms of bond. It's important we get that CCH if a person does in fact have one. Now, a copy of the complaint and the warrant also needs to be given to the arrestee. A copy of the complaint, warrant, completed return should be given to the South Euclid. The South Euclid jail should have that. And then we want to make sure we have copies of all of this stuff, everything that's been prepared, and that it is in the case file and it's been scanned into the OLEG records management system. Next, we're going to go more in depth on the probable cause affidavit, which I had talked a couple times about earlier in this presentation, and go more in depth into just what it's about, what its purpose is, and how we complete it. Now, I said this probable cause affidavit came about as a result of a case that was ruled on by the Ohio Supreme Court, and this case was a case out of Toledo called the State versus Hoffman. And in this case, the court ruled that only a judge or magistrate can determine if probable cause exists to issue an arrest warrant. Back in the day, deputy clerks of courts used to be able to sign off on the arrest warrant on behalf of the judge or the magistrate, and that was pretty much standard practice for most agencies, most jurisdictions, until this case and until the Supreme Court said, can't do it. So, therefore, only a judge or a magistrate can sign the arrest warrant. Clerks of courts, deputy clerks of courts can no longer perform that function. They can still swear you to the criminal complaint and to the facts section of the probable cause affidavit. Now, if we've arrested someone during the hours that the South Euclid Municipal Court is open, we're going to want to make sure that we prepare the warrant, the complaint, the probable cause affidavit. We're going to take those documents to the clerk of court's window at the South Euclid Municipal Court. We're going to advise that we have an arrest warrant and a probable cause affidavit that the judge or magistrate needs to review. And the clerk may swear you to the complaint and to the probable cause affidavit at that point in time. And if they want to do that, that's cool, do so. They may turn around and say, well, you know what, we're going to give this stuff to the judge and let the judge do it. That's okay too, because the judge or magistrate can swear you to that stuff as well. So you've turned those documents in at the window and the judge or magistrate has them in hand, and they're going to then review first the probable cause affidavit. Now, the judge or magistrate may do this in open court. They may do it in chambers. They may come out to the window. You may be asked questions. Answer them. Be flexible. Go with what the judge or magistrate wants procedurally. And after the judge or magistrate finishes with any questions for you, and if they find that probable cause exists, they're going to sign then both their portion of the probable cause affidavit, the judicial findings section, and the arrest warrant. And again, they may turn around and swear you into the complaint and everything in as well. All depends on how they want to handle it, and the procedure is flexible in that regard. Now, during the hours that municipal courts open, ensure that the distribution of documents that I talked about earlier takes place, making sure that the court gets the original warrant, probable cause affidavit, complaint, so on and so forth, the return completed, make sure that they get copies of the report, the video, everything which the court needs to get. I can also work with you on that to help make sure that the court gets what they need. But at a minimum, give the court what they ask for, because the court, for example, may want to complete or can retain the original complaint, warrant, and probable cause affidavit at that time. If they want to do that and keep that stuff, that's cool. If we have the opportunity to complete the return on the original complaint or the original warrant, that's fine as well. If we don't, that's okay, because the return can be completed on a copy and that can be returned to the court as well too. We're very flexible on this. Make sure that the defendant gets their copy, the jail gets their copy, and if the court keeps these original documents but you don't have the police reports, statements, OLEG, all that, that's okay too, because we can take all that stuff over to the court a little bit later and make sure that they have it. They can include it with the original legal documents. Now, we touched upon this a little bit earlier, but the procedures for how to handle the probable cause affidavit and the warrants and whatnot are different when the court is closed. When the court is closed, you will want to make sure prepare the complaint, the probable cause affidavit, and the warrant like you're supposed to. You will go to either the South Euclid Police Department Dispatch Center or to a notary, and one or the other will swear you to the complaint and to the first portion of the probable cause affidavit. Next, you're going to come back to the station, get in the department chair, and find out which court official, whether it's the judge or the magistrate, is the person on call for that given month. And again, that schedule is in the shared drive. You're going to contact the supervisor and brief the supervisor on what's going on. Then you're going to email the sworn complaint, copy of it, copy of the sworn probable cause affidavit, and the completed but unsigned arrest warrant to that duty judge or magistrate. You'll call them on their cell phone and home phone numbers as needed, advise them of the items in their email. The judge or magistrate is going to review the stuff, and then they're going to return the signed documents to you via email. Don't worry about having the original signatures by the judge or magistrate. Not important. They will retain any of the originals that they sign off on. Print out the documents and then distribute them as was previously discussed. Again, as we talked about earlier, don't try to contact the judge or the magistrate who's on call after 10 p.m. If you arrest the person after 10 p.m. or you arrest them before 10 p.m. but can't get everything done, can't get all your paperwork squared away before 10, then you can work with the South Euclid Jail to make a determination on whether the individual should be held until a warrant can be obtained when the court's open or on the next business day. If the individual is held, again, court's open the next day, you got to be there at 8 a.m. with the paperwork to make sure that everything is properly clerked, get the stuff distributed as you need to. If it's on a weekend, again, if you arrest them on a Friday night, you can on the Saturday morning during the day do the email procedure, get the stuff from the judge or magistrate, get it filed accordingly. That's really the preferable way to get it handled, rather than just letting the person sit in jail all weekend without being given the warrant. However, I will keep in mind this: if the judge or magistrate is not available, we cannot get an arrest warrant, and that person is going to sit until we can. For example, let's say the judge or magistrate is on vacation over Thanksgiving and you arrest the person Thursday night. Well, maybe the court's closed on Friday, or the judge and magistrate are out of town and unavailable on Friday, Saturday, and Sunday, and the court's not open until Monday, then that person's going to be sitting in there till Monday without having the warrant served on him or her. We have to work at the availability of the court, and that's what we'll do. So we do the best we can to get this stuff, but if for some reason circumstances don't cooperate with us, we'll act accordingly. Now, if the judge or magistrate, after reviewing all of your documentation, reviewing the facts of the incident, determines that probable cause does not exist to arrest the individual, then that individual is going to have to be released. You'll need to consult with the supervisor as to whether to issue an NDNT citation or whether we should just simply send the case to the city prosecutor for review for charges or to the grand jury in the case of felonies. So keep that in mind, is that possibility could exist. Now, even if a person is not being immediately arrested, let's just say we're simply putting charges on an individual and we're entering them into leads entering the arrest warrant into lead so any other agencies would know that there's an arrest warrant out for them, we still have to complete the probable cause affidavit, like I said, even if the person is not arrested immediately at that time. Now, here's a copy of a blank probable cause affidavit. Again, everything here is pretty much fill in the blank or check box. It's a really easy form to complete, but you got to make sure and have the proper information in the proper locations and that it's complete. And we're going to discuss that as we review the sections. Now, in the first part of the affidavit, we list some identifying information. We list the individual's name, Joe J. Smith, their date of birth. But a little different from the warrant and complaint, we're going to list our report number, and we're going to list us as the arresting agency. Now, the middle part of the probable cause affidavit is really the key to successfully getting charges issued by the judge or magistrate, because here is where we're going to list the facts and circumstances of the offense. So you're going to start by listing your name, and then you're going to provide a summary of the narrative for what you would use in your police report. But the thing which you want to make sure you have in here is that whatever you're charging the person, you have to have described in the facts each element of the crime. So it's very important that you be very cognizant of what you're charging for, and that the narrative fits the particular statute and subsections of the statute, and all of the elements of the offense are met within your statement of facts. For example, if there's something damaged, you have potential of criminal mischief, criminal damaging or endangering, or vandalism. So it's very, very important that you just don't assume that a particular offense is what it is, and that you review the actual statutes and look at the elements of the offense, find out which one accurately fits it, and make sure that that narrative section covers all of the elements of the crime listed in that statute. Now, in the bottom part of this, it says the basis for this in whole or in part is based upon the following evidentiary sources information. And this could be your investigation. It could be witness statements. If it's witness statements, make sure they're attached to this form. And if you have any additional pages, for example, if your facts narrative extends beyond the block that's contained on this one page, type it into an additional blank page and attach that to the probable cause affidavit and check additional pages attached. If you have witness statements attached to the form, click both the witness statements and the additional pages attached as well. Now, this section you can be sworn to. You can have it sworn before a deputy clerk of courts or a notary public, whoever is available. Now, the last part of the form is the part that's going to be completed by the judge or magistrate. They're going to review this, and they're going to look at the fact statement which you have in the section above, and they're going to make a determination if there is probable cause for the person to be arrested. So if there is probable cause to arrest the defendant, the judge or magistrate will check the block stating that there is, and then he or she will determine what the nature of the bond is to be set. In this case, $5,000, 10% cash, and if there's certain bond conditions, for example, because this was a trespass case, Mr. Smith is not to be on the property of Notre Dame College. If he's found later on, not only can he be arrested and recharged, his bond could be revoked and he could lose it as well. So the judge would then date it and the time that it's signed, and also keep note that if the judge or magistrate says that there is not probable cause based on the information provided and they check that block, remember, we're going to have to release the individual. Well, that concludes this presentation of NDNT citations, long form warrants, complaints, and the probable cause affidavit. If you have any questions regarding the content of this course, please feel free to talk with your field training officer, or you can contact me and I will be happy to answer any questions that you may have as well. And at this time, you can turn around and take the online examination for this course, and if it is successfully completed, it will be noted in your field training record. And if for some reason you don't have a successful completion, we can review the parts that you missed where you might have had problems, and you'll be given the opportunity to retake the exam. So thank you very much for attending this course, and good luck to you on the exam.